So climate change is having significant detrimental impacts on developing countries, including small island developing states. These impacts are increasing in frequency and severity, leading to incidents of loss and damage, including climate-induced migration and displacement. Vulnerable communities within these countries are most at risk. Climate impacts are attributable to both state and non-state actors, and recent decisions at the UK Supreme Court have changed the way we normally view the separate legal personality of parent companies within multinational companies in the context of environmental and climate justice. Over the past 25 years, determining how to enrich our world in a more sustainable fashion has become an imperative, especially given the impact of development on the environment and human rights. The McGill Journal of Sustainable Development Law provides a forum in which the world's leading scholars exchange ideas on the intersection between law, development, the environment, economics, and society. So today it is my pleasure and our pleasure to introduce Professor Lisa Benjamin, who is an assistant professor at Lewis and Clark Law School in Portland, Oregon. Her research investigates the intersection of corporate, energy, and environmental law with a focus on climate change and climate risk. She also researches climate change from the perspective of developing countries with a focus on small island developing states. Her doctoral studies focused on carbon major companies, corporate and energy law, and climate change, and she has a forthcoming monograph with Cambridge University Press entitled Companies and Climate Change, Theory and Law in the United Kingdom. After completing her PhD with the University of Leicester, she was an Oxford-Princeton Global Leaders Fellow at the Blavatnik School of Government of Oxford, a visiting assistant professor at Penn State Law School, and a Killam postdoctoral fellow at Dalhousie University in Canada. She is currently a member of the Compliance Committee of the United Nations Framework Convention on Climate Change and has been an advisor to and member of the Bahamian National Delegation to the United Nations Framework Convention on Climate Change. So welcome, Professor Benjamin. Thank you for being here.
Thank you so much for such a kind introduction and welcome. Thank you to the journal for inviting me. I actually did my undergraduate at McGill, and so it's so nice to be back, even if it's virtually. So I'm really sorry that I can't be with you in person to see the campus again. Those were very happy years. As Melanie had said, I'm from the Bahamas, so I'm from a small and developing state. I found Montreal to be extremely cold when I moved there, but also it's informed my research agenda, my approach to climate change and to climate justice. And also when I did my PhD, I practiced in commercial law. And so I then did my PhD in this combination, at the time, quite unique combination of corporate law and climate change. And so actually I have a little bifurcated research agenda. And this is the first time, funnily enough, that I've actually brought them all together in one presentation. So I think it's fitting that I'm doing that at McGill, if at least virtually. So I'm really pleased to be here, and thank you very much for the enthusiasm for my research topic. So I'm going to share my screen, and I'm going to speak for probably about 45 minutes, and then we'll have some time for questions afterwards. So I'm really focusing on multinational companies and the way that they have historically acted in relation to the global south. And I'm going to actually, so there's three parts to my presentation. First, I want to look a little bit at the concepts of climate justice. They are varied. Look a little bit at these concepts of loss and damage, which have become very prominent in the negotiations, and how they are linked to displacement, and a couple of really new cases that have started to be brought around the world on climate-induced migration and displacement. And then I want to shift to the second part of the presentation, which is about the history of multinational companies around the world, and also how they are acting now in terms of climate justice and environmental justice. And then the third part of my presentation is really about corporate law and some of the new changes in the United Kingdom, which is important for Commonwealth countries like the Bahamas and Canada, about how they are sort of reframing the concepts of multinational companies, particularly in relation to environmental justice and why that matters for climate justice. So climate justice is huge. It's a big topic. And it's actually very broad in terms of its historical development, In particular, I want to focus on the relationships of colonialism and neocolonialism. It is certainly about racial justice and structural disadvantage. And so often communities within global north or developed countries, it's the more vulnerable socioeconomic communities that are most disadvantaged and most vulnerable to climate change. And that's the same around the world. So in global south or developing countries, those really are the most vulnerable countries to climate change. And it's actually vulnerable communities in those countries that are even more vulnerable. So it's certainly about human rights. It's about civil rights. It's also vastly about planning and development within countries, but it's also about existing geographic wealth gaps and racial wealth gaps. And they are very much related to each other. There is going to be a lot more climate-induced migration and displacement around the world. And so we're just starting to see some cases, and the legal structures that exist are not appropriate to manage them, and we're going to see more of them. And then, of course, it's about communities themselves, which I probably don't have as much time to talk about, but about communities themselves creating their own resilience, and really being able to access health resources. It's about sort of socioeconomic and political conflicts in countries, which are also exacerbated by climate change. So we can think about drought. And of course, images. So the images of vulnerability, the images of brown and black people in relation to climate change and climate justice are really important. And they have also come to the surface quite a lot. So I'm not a climate scientist. I really don't like talking about climate science because it is so complicated. But I do want to say that this 1.5 report by the Intergovernmental Panel on Climate Change, which is the premier international institution on climate science, has already told us several times that we should be trying to limit global temperature increases to 1.5 above basically our global mean temperature average now. We're at about 1 degree Celsius, a little bit more. And we know that if we are able to keep global temperature increases to 1.5, the impacts will be bad, but they won't be as bad as they will be if we get to 2 degrees and above. And even with limiting temperatures to 1.5, which is going to be challenging, the worst impacts will be felt in the Southern Hemisphere, and so in global South countries. There are going to be disproportionate impacts even at 1.5. And so those impacts will fall disproportionately on disadvantaged and vulnerable populations. And those include small island developing states like the Caribbean, where I'm from, indigenous communities, subsistence communities. And these impacts are going to be multiple, cascading, and they will compound each other. And so they're going to really build on each other and get worse and worse over time. And that is borne out by some of the research that I've done with a colleague, basically in Caribbean states and Pacific states. So when I negotiated in the Paris Agreement, the Bahamas as part of the Alliance of Small Island States, or AOSIS. AOSIS has had a very strong presence in the negotiation and has had as its mantra and slogan 1.5 to stay alive. And that is actually very, very truthful. A number of Pacific islands in particular are facing slow onset events like sea level rise, and it is making some areas of their countries uninhabitable. And we'll look at a case from Kiribati, which talks about that. So when I'm talking about vulnerability, it's also a really complicated topic. It evolves over time, but it's basically exposure and hazard, and that affects livelihoods. So if you have a lack of resilience, so you are not able to access healthcare services, or you are food insecure, or you live in very vulnerable and exposed parts of your country, then you're going to be much more vulnerable to the impacts of climate change, much more so than other people that live in your country. And then the causes of vulnerability are also complex. So they are both natural. So we can see extreme events like hurricanes and typhoons are getting much more intense and much more frequent. But it's also a human development concept. So where have you developed? If, like the Caribbean, you develop on the coast or near waters that will rise, then you're going to be much more vulnerable. And there has been, environmental mismanagement within countries. So we're not only facing a climate crisis, but we're facing a biodiversity crisis. And so socioeconomic impacts are really important for vulnerability as well. I'm going to very briefly talk about loss and damage. It's not well defined, purposely so, in the negotiations. And so we have these sort of vague definitions in the negotiations. So the small L and small d loss and damage are basically things that involve more than what you can reduce by adaptation. So the easier way to think about this are the impacts that happen that go beyond adaptation. So things that you just cannot adapt to. And they are going to affect us and happen despite the global mitigation and adaptation efforts that we're taking now. So even if we step up existing global mitigation and adaptation efforts, which we have to do, there are still going to be impacts of loss and damage in particularly vulnerable countries and in vulnerable parts of less vulnerable countries. So an example of loss is irreparable loss. So it's something that you just can't get back. And so for the Caribbean, that's been a huge problem of coral reef bleaching. When coral reefs bleach, they sometimes can come back, but they often die and they're gone for good. And so the difference between 1.5 and 2 degrees, at 1.5, we will lose approximately 90% of coral reefs around the world. At 2 degrees, 99% are gone. Another example of loss and damage is freshwater lenses. And some countries depend on freshwater lenses. If those freshwater lenses, because of sea level rise, are punctured and they become salinated, that freshwater resource is gone. So it's permanently lost. Damage is slightly different. So that's where you can actually recover. So this is an example of a highway in the Bahamas that was just washed away in a hurricane. So it is, of course, possible to rebuild these, but it's just very expensive to do so. Another example of damage is something that's just technically really difficult for a country to replicate and rebuild. So what leads to loss and damage? It's very closely associated with vulnerability and lack of resilience. And so if you have very vulnerable parts of your country, populations that live on the coast, high levels of poverty in your country, inequality, so gender equality is really important for climate resilience. And then of course, access. So access to things like health and infrastructure to be able to remove yourself from an extreme event, those are wealth related. And so where you have impacts over time historically on reduced wealth, that means you have reduced climate resilience. So climate-induced displacement and migration, this again is a contentious term. It's not covered by refugee law at the moment. And so the definition that you often see is basically a response to climate-induced impacts. And so when people are leaving their home as a result of extreme weather events or slow onset events to find a safer place to live. Most of the climate-induced migration displacement will happen within countries. So particularly for large countries, Bangladesh is a good example. There will be a lot of internal migration and movement, but particularly for small and developing states, and that's, or even very vulnerable people within existing countries, they may want to move because of climate change as well. So we'll look at briefly at two cases. One's from Kiribati, and the other is a claimant from Bangladesh. No, sorry, Pakistan, sorry. So some of the research that I've done with a colleague, Dr. Dell Thomas, is in relation specifically to loss and damage and how it's dealt with at the climate negotiations. And what we've seen is that climate impacts have impacted the most vulnerable people within populations. So even in global north or developed countries, it's often the elderly that feel the most impacts, children, women, pregnant women, impoverished communities. Those are the ones that are bearing the brunt of climate change and unfortunately have the fewest resources to be able to actually recover from those impacts. And they are cascading and cumulative. And so even if you have development gains within a country, socioeconomic development gains, the impacts of climate change will basically roll back that development gain. So you sort of lost the gains that you had actually worked hard to improve the livelihoods of your populations. And so Adele and I have come up with this, what we call the unvirtuous cycle of loss and damage and the impact that it has on resilience. So many global South countries have capacity constraints, and that's human, financial, and technical constraints. That leads them to produce fewer public goods in the first place. And so they have fewer public policies. If you have an incident of loss and damage, let's say a hurricane, you have to divert money from your existing public budgets because it's very difficult to get international assistance or at least regular financial assistance to be able to recover. That means that you have less funds available in your public budget to invest in policy formation. That leads to even more capacity constraints. And it's just a cycle. And so this is an example of how development gains that you can make in your country then are actually negatively impacted by climate change itself. And ironically, that means that countries have less funds and less capacity to invest in adaptation to climate change. And so we did a research project where we interviewed 7 negotiators from small and developing states in the Caribbean and the Pacific. We reviewed the first round of nationally determined contributions, which are submitted under the Paris Agreement. And we were looking specifically at how countries were managing in terms of policy documents, loss and damage within their countries. So these are all small and developing states. And what we found was that people told us, the negotiators we spoke to told us, and their policy, their nationally determined contributions confirm this, that countries themselves don't have a lot of data on the impacts of loss and damage. So what kinds of impacts they're suffering from. They also are not able to financially assess the impacts of loss and damage, and that's because they suffer from these capacity constraints. And there weren't a lot of targeted policies specifically looking at loss and damage. Instead, what countries would normally have would be like a adaptation policy. So they would have a broad adaptation policy, but often that was a few years old and would not even mention the term loss and damage because it is a relatively new term. And in particular, countries did not have policies on slow onset events. And so that's things like sea level rise or acidification of oceans. And it could confirm this sort of unvirtuous cycle when we looked at it, that some very vulnerable countries are really struggling to deal with the negative impacts of climate change. They are diverting public resources away to build seawalls and to be able to implement both soft and hard adaptation measures. But that money, that public money, is being diverted from other things. And those other things can be like health and education and poverty reduction and all those things. And so that means that you are inadvertently making your population more vulnerable by doing that. And then we did a similar exercise where we focused in Pacific and Caribbean states on climate-induced migration and displacement. And so again, we found that countries had very few policies specifically targeted at how their populations may have to move in the future. A lot of where there was migration, a lot of these instances were ad hoc. And so the government would just be reacting to, let's say, a hurricane and moving people from an island. And our recommendations for governments was that a much more comprehensive policy approach needs to be implemented, and that should be stakeholder driven. And so consulting with communities is really important. There are regional policy bodies that can help in terms of the Caribbean and the Pacific. People will not want to move unless they have been consulted and have a place where they feel comfortable moving to. Even within countries, within small and developing states, you have different islands or different cultural populations. You can have different sort of clan relationships, particularly in the Pacific. And so even migration and displacement within countries may not be entirely smooth. And so you need to make sure that you are consulting with both the communities that may have to move, but also the receiving communities. And that's really important, even in small states. So I wrote this blog with two colleagues of mine at Dalhousie, and this was a UN report specifically looking at extreme poverty and climate change. And it really makes it very clear that there are racialized aspects to climate migration and the impacts of climate change. So the people that will be most affected, and we're talking about hundreds of millions of people, will be the most vulnerable people in parts of Africa, Asia, and Latin America. And so it's a lot of people that may be affected by the middle of the century. And of course, we know that the appetite for immigration, particularly in richer countries, is not very conducive at the moment. And of course, if you have the most vulnerable parts of your population who want to migrate, then there's going to be a lot of issues and tension around this. And then finally, we looked at a specific element of loss and damage, which is called non-economic loss and damage. And so economic loss and damage are things that can be priced on markets. So you have a road that is washed away, you've got to rebuild it, there's a price tag to that. Non-economic loss and damage is different. That is things that can't be priced easily on the market. And that's things like your cultural relationship with your community, access to sort of heritage sites, to your ancestors, to burial grounds. Those kinds of things are really difficult to price in a market, but they have a really strong pull in terms of communities and what communities decide to do. And so we assessed the impacts of non-economic loss and damage in one particular island at the Bahamas called Ragged Island. It's a tiny little community of about 300 people. There was a hurricane that hit the island, Irma, and it just devastated the island. And so the water reverse osmosis plant was destroyed, the police station was destroyed, everything was gone. And so the government flew a plane in, evacuated all those 300 people, took them mainly to the capital. And then there was this question of whether or not the government would spend money to rebuild on that island. The community was very clear that they wanted their community to be rebuilt. The government was told by an international financial institution that it was not, the cost benefit analysis was not worth it. And so they were unlikely to get a loan to rebuild that community. And the community itself was so angry after a year with governments sort of really not being very clear about whether they could move back, They actually raised money themselves through the Ragged Island basic cultural association of people who grew up and lived in Ragged Island. They rebuilt their own police station, their school, their water reverse osmosis plant, and they moved back. And that is an example of a very ad hoc reaction. And it's because they wanted to live in their home. They wanted to live in their settlement because they had such strong cultural ties to it. And so, not planning for that by governments is going to mean that those communities may actually be entrenching existing vulnerabilities by moving back to those communities because it was completely unplanned. And then finally, sorry, this is the last one. Our latest paper is looking at gender and climate justice. And so we looked at the relationships between gender policies, which most Caribbean countries have, disaster policies, which are often separate from climate adaptation policies. And we looked across them in 13 countries. And what we found was this very little overlap between these policies. So the most you would probably get would be an adaptation policy that would say, we understand that gender, entrenches vulnerability, but there's this huge policy disconnect. And that is problematic because in terms of equality for women, Latin American the Caribbean is one of the most unequal areas in the world in terms of gender equity. And so that really needs to be addressed in terms of making sure that the most vulnerable members of societies are prioritized in climate change policies. So these are the two cases that I had mentioned earlier. This is the first one where there was a migrant, Mr. Tiotota from Kiribati, and he applied for refugee status in New Zealand, was refused. And he then took his case to the United Nations Human Rights Committee. And it was a really important and one of the first instances where the committee actually realized and stated that climate change could actually be a driver of migration and displacement. And so that statement by the committee was a really important one. And this is the reason why Mr. Tiotota said he could no longer live on the island in Kiribati. Mainly it was because of slow level onset of sea level rise. And as a result of that, the soil had become salinated, so he could no longer farm. So he was a farmer. There was a lack of fresh water. There's just less land to live on. And so people were becoming very crowded on this island. And that lack of space and housing caused a housing crisis, which caused a violence. People had died as a result of this violence. And so his claim was very much illustrative of these drivers of climate change from slow onset events. And the committee said, okay, we recognize that these things are happening, but they're happening to everyone. They're not just happening to you. And so they refused his claim. And what I thought was really interesting was they said, okay, we know in 10 to 15 years, which is not a lot of time, that people will no longer be able to live in Kiribati, in Kiribati. And so we think that the government, with help from the international community, is supposed to fix the problem and move people, basically. And I just find that to be kind of astounding that the responsibility is primarily put on the government for the impacts of climate change, which Kiribati, the Republic of Kiribati, is absolutely not responsible for. And so it really, although it's a really important statement that climate change can be a driver of migration and displacement, it provides absolutely no solutions for this, except saying that the country itself, which is, as I discussed, not able to manage this issue, is supposed to manage this issue. Oh, and you have to do it in 10 to 15 years. And if you get assistance from the international community, that would be great. So the legal structures that we have are just not appropriate to managing this crisis. And this is a very new decision in France, which is the petitioner from Bangladesh was suffering from respiratory illnesses. So he claimed status in France, arguing that his condition was exacerbated because the air pollution in Bangladesh, which is a highly vulnerable country to climate change, meant that he was not able to live there anymore. And he was actually successful. And the Court of Appeal in this instance decided that climate had actually exacerbated his respiratory illnesses. And so this is the first example of the ability to claim refugee status in France from air pollution, which is induced by climate change. So this is the second part of my presentation where I really want to look at what do companies have to do with this? I mean, we know that the small and developing states, developing countries are really struggling to manage the impacts of climate change. And I really want to go back to colonialism. When I teach environmental justice, I always go back here because I think it's really important to understand that not only was the colonial system incredibly racially exploitative, really took land from indigenous communities through North America, South America, and Latin America. There were genocides of populations, so the indigenous community in the Caribbean is just gone. They were eradicated. But in addition to that and the horrors of colonialism, it was also a political and economic system. So it was an economic system that extracted wealth and predominantly raw materials from global South countries, and this is just the Atlantic version of it, and took those raw materials to global North and wealthy countries. And this is an image that I always use basically of an ecological debt. And so raw materials were taken from these countries without their consent and used to fuel the Industrial Revolution in global North countries. And so this created an economic system where consumption and lifestyles in global North countries were subsidized by exploitation of many levels, economic, political, and racial exploitation in the global South. And that led to levels of consumption in wealthy developed countries that were subsidized by the materials in global South countries, because the levels of consumption in global North countries cannot be maintained without raw materials from other places. And so that meant that the cost of goods that people in wealthy countries got used to consuming did not reflect externalities or negative externalities. And so those externalities were largely experienced and suffered in global South countries. And that economic system built levels of wealth on the basis of that we still see in terms of consumption levels today. So the majority of materials, raw materials, are consumed and used in global North countries. And those high levels of consumption are fueling the crises that we are seeing, the climate crisis, as well as the biodiversity crisis. And these patterns of exploitation and economic patterns have been around for a long time. And so, for example, this is a headline talking about wealth and how wealth is really driving climate emissions. And so it really is the richest 1% that is causing emissions much more dramatically than the 50% of the poorest of the world's population. And so economic inequality and extreme wealth is really a huge driver of climate change and climate emissions. And companies have absolutely been a partner in this relationship. So they have been around since colonialism. So on the left is the British East India Company, which was the vehicle for colonialism through the British Empire. The Anglo-American Corporation, very active in Africa in terms of exploitation of oil and gas, the Hudson Bay Company in Canada. So corporations have been around for a very long time, and they have really been the vehicle that has been used to manage this kind of economic exploitation and racial exploitation. So I use this scholar, Norman Gervin, who's a Caribbean scholar, who wrote this book some time ago talking about corporate imperialism, the idea that corporations themselves were partners and facilitators in the colonial project. They were the entities that could establish and manage colonies in the global South. And so they, for example, a British East India Company had basically a government and managed the British affairs in India. So these companies were able to establish levels of power and influence through governments. They were highly involved in extractive industries like bauxite in the Caribbean, oil and gas all over the world, the extraction of minerals. And this corporate structure institutionalized these power dynamics. And so this is a illustration of the Standard Oil cartel, which was broken up obviously into the carbon major companies that we know of today. But Peter Michalinsky does a great job at explaining that the Standard Oil cartel, in terms of extraction of oil and gas, used the transnational or multinational corporate structure to be able to establish locations in the global South where they would do the extraction, and then of course benefit from it in their parent company. And so companies have really used these corporate structures to benefit and expand their operations around the world. The corporate structures are domestic based predominantly. There are very few transnational laws that regulate companies at an international level, and companies have really used this to their benefit. So it's not like we didn't know about this. And so in the 1990s, we knew about sweatshop labor in Nike. We know about it for iPhones as well. Ken Saro-Wiwa, the execution of an outspoken leader in his community in Nigeria, has all implicated companies. And so legal systems have not been able to manage both the environmental extraction and externalities that have resulted as a result of these activities, and or the human rights violations that have accompanied them. And often they are very much related to each other. And so this has been a concern for some time. It's also not just, many, many years ago. So there is continuing exploitation in global South countries from new dominant powers in the world as well. So this is a continuing system. And it means that from the first part of the presentation, the communities in the global South that are experiencing the most dramatic impacts of climate change are also the ones that are living with the economic and racial legacies of colonialism. They can often be communities that are subsistence communities, and so highly vulnerable to the impacts of climate change. The companies themselves, we know, we have seen that they historically over time have emitted massive amounts of greenhouse gases, and the communities themselves are often not able to bring claims against the parent company because of access to justice issues, and also because of corporate structures. And so there are multiple equity binds in this relationship. They've occurred over time, and they have been cumulative over time. And so this is a paper that I'm referencing. It's called the Carbon Majors paper by Richard Heaty. He actually was the first one in 2013 and 2014. He published a paper where he looked at the emissions of about 90 carbon major companies. These are major oil and gas companies. And he looked at them over time. And what he found was that cumulatively and historically, these companies, some of them are investor owned, some of them are state owned companies. But what he found was they were responsible cumulatively and historically for 63% of global emissions. And so non-state actors in terms of companies are themselves responsible for a tremendous amount of emissions over time. And so the question then becomes, well, how are they managing this relationship? I know you've had a speaker already that has talked about the climate litigation around the world, so I'm not going to talk about the litigation being pursued against companies. I really want to focus in the last section of my talk on the concept of company law and multinational companies, and how this concept of the corporate group has now actually been changing a little bit over time, and how that relates to issues of environmental justice and climate justice. And so companies themselves are in this inflection point where they're realizing, particularly because of economics, so the impact of COVID-19, but also the changing and shifting economics around renewable energy. Some carbon major companies are now realizing that they are no longer able to continue the pattern of exploitation and resources that they have used for so long in terms of fossil fuels. Basically, the tide is turning against them in terms of social opinion. And I think partly that is because of the impacts of climate change are getting worse, but also we now realize how much they have contributed to the climate crisis, and how much they have not acknowledged that. And so companies themselves, for the most part, or at least they say they're very concerned about their social license to operate. For most of the existence of company law, not entirely, the entire motivation of company law has been to maximize the wealth of shareholders. And so we are now seeing this structure really become questioned, particularly in a recent series of cases in the United Kingdom. So if we think about a traditional equity-based groups where shareholders own shares in companies, you have a parent company, and that parent company is often registered in a global north country. And then you have lots of subsidiaries. So you could have intermediate subsidiaries like subsidiary 1 and 2. And then let's say 3, 4, and 5 would be based in a global south country, and they would be the ones actually doing the extraction. And all of the profits from that sale of these resources go up to the parent company. So the parent company, usually through dividends, will get the economic benefit of the activities of the subsidiaries. But all of the liability through company law is cabined or sequestered into specific individual companies because of principles of company law. So you get all the benefits going up, and then you get all the liability going down into subsidiary companies. And that's because of these core principles of company law, which is separate legal personality. Each individual company is a separate person under law. And in addition, shareholders have limited liability. And so the parent company will be able to limit its liability, often to the amount unpaid on its shares. So if it's paid for all of its shares, then it doesn't have the liability for the debts of the subsidiary. And this concept of a corporate shield really was the motivation for having company law in the first place. And it's been around for a very long time. And so in the UK, for example, which is the model of company law that many Commonwealth countries have adopted, you have the idea of unlimited liability, but the separate legal personality in an act in 1844. And then some 10 years later, you actually have the concept of limited liability coming along. So although we often think of them as one and the same, they actually came along at two separate times. And limited liability was actually contentious at the time. And some of this is really good. So limited liability means that shares become fungible. You can sell your shares because they don't have debts attached to them, because you have limited liability. That means as individuals, for example, you can diversify your savings. So you know that you invest in company A, you're not going to be stuck with the debts of that company. You can then put money into company B as well. It means that capital markets are really liquid. It's, it's led to a tremendous amount of prosperity around the world. And it means that as shareholders, you don't have to monitor what your directors are doing, because ultimately you're not liable if they make horrendous mistakes. But of course, there are some problems with this. So limited liability doesn't get rid of liability, it just shifts it. It just shifts it basically to creditors. And where you have a voluntary creditor, like someone like a bank who's lending money to a company, they understand that they're lending to a company, that company has limited liability. And so they can sort of cater for that risk. So they can actually get insurance for the loan that they make or any goods and services that they sell to the company. They can get security, so they can get a pledge or a mortgage from something. They can raise the price of what they're selling and say, okay, like I know that, I can't go after the shareholders, so I'm going to just charge you more for what I'm selling to you. Or they can decide not to deal with the company and say, sorry, I'd rather deal with another kind of form. The problem really becomes in this context of the cases that I'm going to talk about, involuntary creditors. These are tort creditors. These are people who have no ability to protect themselves in advance from the activities of the company. This is particularly problematic where those tort creditors are based in global South countries. And that is because in those countries, often what companies will do is for the subsidiary based in the global South country, they will undercapitalize it. So there's just not a lot of resources to access if you are going to sue the company. And in those countries, often developing countries, there are significant problems in access to justice. So they may not have the ability for claimants to actually bring claims through the court system. And so limited liability is really only beneficial where you have voluntary creditors, where they're individuals, where the shareholder is a company. They don't need limited liability. Courts have always been uncomfortable with this. So from the time that limited liability was established, there's always been the ability of courts to what they call pierce the corporate veil. And so that means that they can actually see through the separate legal personality of the company and then go after and make the shareholders responsible. Piercing the corporate veil has sort of fallen out of favor in the UK and other jurisdictions is still alive and well. Courts have often done this in unpredictable circumstances, and they've often done it when they feel like the behavior of the company is reprehensible. So there's always been this tension of, well, you have this corporate form, you can use it, you form a company to get limited liability in the first place, but then when you abuse it, according to courts, they say, oh, no, you can't have it anymore. We're going to pierce the corporate veil. And you can see how that can be unpredictable for companies and for industries. And so I'm going to talk very briefly about a new set of cases in the United Kingdom that have reconceptualized this concept of a parent company and whether a parent company should be responsible for the activities of its subsidiary company. And we're seeing this new duty arise, particularly in the United Kingdom, because piercing the corporate veil has really gone out of fashion. So courts are not doing that anymore. What they have done is sort of reconceptualized it in this concept of a parent company and whether or not they should be responsible for the acts or the omissions of their subsidiary company. It started out in terms of employees of that subsidiary company and responsibility to employees of that subsidiary company. And now the courts have really expanded this beyond employees to actual third parties. And we've seen a lot of cases in the United Kingdom in communities around an extractive company in the global South that are actually arguing that they want to be able to sue the parent company for this. So this really started in 2012, and I'm going to go very briefly through the cases just to give you a flavor of what they say. But you can see in the last couple of years, we've had a number, it's been really active at the Supreme Court. This idea of parent duties is becoming very active, and the majority of cases now, really after the Chandler and Cape case, which is based in the UK, the majority of claimants are now from global South communities, from vulnerable communities who have suffered as a result of the activities of the subsidiary company and are now bringing claims in court. And so, very briefly, the Chandler case, which started this all off, was about asbestos. This was a factory. You can see the walls were open. The subsidiary company actually allowed the parent company, the subsidiary company made bricks, allowed the parent company to use its factory to create asbestos boards. An employee of the subsidiary company developed a lung disease as a result, and the subsidiary company didn't have insurance, and so he sued the parent company. And the courts held in 2012 on the basis of 4 what they call the Chandler factors, that the parent company could have duties to the employee of a subsidiary company if they're in the same business, if the parent should have known about the impacts of asbestos board, for example, which they did know because it was open, it went everywhere. The parent company knew that the subsidiary's operating systems were unsafe because they had actually sent a doctor to look at it. And the parent knew that the subsidiary would rely on the parent's knowledge. And so when these factors, the Chandler factors, are satisfied, that meant that liability could be imposed on the parent company. And then basically after the Chandler case, which is based in the UK, all of the cases since then have involved the Global South. So the Vedanta case, Vedanta actually bought these resources from Anglo American, which is one of the companies that I talked about in terms of involvement in the colonial project. They bought this copper mine in Zambia, KCM copper mine, and the community around the copper mine suffered from water pollution and sued in the UK, sued the parent company in the UK. And the High Court said actually this neighboring community, so third parties, they didn't work for the company, we could extend the Chandler factors to these communities around this mine. The Court of Appeal said, we agree, like these group policies that they have. So every parent company will have a group policy in relation to climate change or environmental impacts. They talk about sustainability. The Court of Appeal said this liability of a parent company could arise as a result of these group policies. And the Supreme Court agreed, they accepted jurisdiction. And so the Supreme Court said that the parent company could have duties to this community. And the decision in the Supreme Court, which was accepting jurisdiction only, left it very open as to which corporate model they could impose this duty on. And they said that these, this group policy of one vision, one entity, you can't sort of say all of that and say we're responsible, we're one global brand. And then when it comes time for liability for the neighboring communities in Global South, say, oh, no, that's not our company. That's a separate legal entity. So the Supreme Court accepted jurisdiction. Fortunately or unfortunately, there have been some tensions between the mining company's subsidiary and the Zambian government. And so the Zambian government may actually be taking the mine back. And so it's unlikely that this will be heard substantively at the Supreme Court. But this initial decision on accepting jurisdiction was a very wide one. And then this case from the Okapabi community, the Ogali community, King Okapabi is a customary ruler of this community in Nigeria. There's been a very long and very contentious history of Nigeria, of shell in Nigeria. And there's been a ton of pollution around these plants, particularly leaking pipelines. And so this community sued and said, we want to sue the parent company Shell for damages. So the Court of Appeal said, the High Court said, no, we're not going to extend these factors from the Chandler case to this particular circumstance. And the Court of Appeal affirmed, and that's because the Court of Appeal felt like the subsidiary company, the Shell Development Company of Nigeria, they were the ones that held the license from the government to operate the plant and the leaking pipeline. And so as a result of that, the High Court and the Court of Appeal said the parent company was not actually operating anything on the ground, did not have control. And then there was a dissenting opinion by Lord Justice Sales who said, actually, the parent company knew about all of this. The parent company knew that this pipeline was leaking. They knew that the subsidiary company was mismanaging these resources. There was this practical assumption of control by the parent company. And that dissent becomes really important when the Supreme Court heard the case just this year. So before I get to that Supreme Court case, there's another case with Unilever in terms of tea and tea plantation workers. After the election in Kenya, the workers on the plantation were raped, murdered, and assaulted. There was a lot of violence. And as a result, they sued the parent company Unilever for the damages that they suffered. The estates of the workers as well sued. And the Court of Appeal said, no, we're not going to extend the Chandler factors, even though Unilever had this like one Unilever policy, they said that was not enough. The managing director of Unilever, I think for the subsidiary company, was very persuasive in the Court of Appeal and said basically Unilever doesn't really, this is not really part of their main strand of their business. They're not involved in tea. It's mainly consumer products now. And so I would never have called the parent company for expertise or advice. And the Court of Appeal was persuaded by that. However, I think it's important to note that Unilever is facing boycotts around racial injustice and underpaying of their workers in Kenya. So, and then finally, so we thought it was sort of over when the Vandante case was not going to be heard substantially by the Supreme Court. And then the Poppy case, it's actually two cases, but they appealed to the Supreme Court. And the Supreme Court just this year picked up on the dissent by Lord Justice Sales, accepted jurisdiction to hear the case. And they said the Court of Appeal had taken much too narrow of a view of the duties of parent companies in these circumstances. And so I think this will actually be heard at the Supreme Court unless the parties settle. This has been a long time coming. There have been decades and decades of mismanagement of Shell and their resources in Nigeria. So it's a really exciting time to see if we will have a substantive decision on this issue by the Supreme Court in the United Kingdom. And so even though it's a really exciting line of cases, I still think that we need more legislative reform. You can see that particularly with the Unilever case and the Vandante case, the concepts of control are really nebulous. It really depends on what a company has done, what their policies say, did they know, did they assume control? And it's literally a case-by-case issue. And my theory is, shouldn't the law just say, if you're benefiting economically from this activity, you should be responsible for the activities of your subsidiary. And so if you're in an enterprise and you're getting dividends and you have control relationships, then you're responsible. And so if legislation says that at the outset for group companies, at least they will know in advance if they want to form a company and a corporate group. There are other options as well. You could sort of remove limited liability. So you could say that there is a presumption of unlimited liability unless the parent can rebut that presumption. Enterprise liability, I think, is just a cleaner approach. So every corporate group will be responsible. And that means that you don't have to prove control in all the instances. So I think that we will see this series of cases is becoming very active in the UK. I don't know if we'll see legislative reform. And so finally, I just want to end by bringing it back to our the original part, the first part of the talk about climate change and climate justice. So there are a series of cases on climate harms and tort. And so if they are successful and if they are able to establish liability, that means that particularly for parent companies based in the UK, if this line of cases are successful, the parent company could also be responsible. And I also finally want to end by just saying, well, environmental justice and social justice is climate justice. It's really important that these communities are able to have a healthy community that they can live in, because climate resilient societies are financially stable. They're able to recover from shocks. They have access to health resources. They have access to subsistence farming and fishing. That means they have healthy resources in their communities. And so communities need access to wealth, equality, and healthy resources to be able to withstand the shocks of climate change. And so it's also important from a climate perspective, even if these cases are not entirely centered around climate change itself. And that is it. Thank you very much.
Thank you so much, Professor Benjamin. That was so interesting and inspiring, quite frankly. I know for me as a 1L student, I'm really looking forward to explore more of these issues in the coming years. And so thank you.
You're very welcome.
We're gonna welcome any questions that participants may have. You can either raise your hand or write questions in the chat. I see that, Laurence, you have a question? Go ahead.
Yes, hello. So thank you for the presentation. I was wondering specifically about if you're familiar with the Chevron Texaco case in Ecuador. And there was one of the trials that came to Canada, and this was kind of a reverse situation where they couldn't hold the subsidiary responsible for the parent company's wrongs. And I'm wondering if there are any examples of that actually happening.
So that is reverse piercing. So thank you for the question. So that is reverse piercing, where you are traditionally would pierce up through the subsidiary to the parent, but that is reverse piercing. And I think that's been a very contentious set of cases. I think the lawyer is under house arrest now. I mean, there's just so many, it's such a complicated set of circumstances, but I think it's really an important one. There's also, I'm aware of the Nevson case in Canada, which is talking about customary international law and human rights, and whether or not a company can be responsible. And in theory, that case says that they can for international human rights. So you can have reverse piercing from the parent company down. And I think that illustrates, and it does happen, not that often, but it does happen. And I think that illustrates how closely related these companies are. In theory, under company law, they are separate legal personalities, but in reality, they are not. So they are close relationships. You often have directors of parent companies sitting on the board of the subsidiary companies. There's very close operational relationships for reputational issues, but also because of financial issues. And so I think this idea of them being separate legal entities under law is just not correct. And it's not accurate, and it's not just, frankly.
Right. We have another question from the chat saying, do you think Canadian courts would ever recognize the corporation subsidiary employee relationship as a category of proximate relationship where there is a duty of care?
I think it's, so let me say that I'm really excited about this line of cases in the UK, but I recognize that it's really hard to do. So I was actually really surprised when I started seeing these cases come out, because courts for so long have been so wedded to this idea of separate legal personalities of companies. It is the bedrock on which company law rests. It is the bedrock upon which a lot of money is made by corporations and investors. And so to see this real sort of shakeup is unusual. It's exciting. But I think if it can happen in the UK, where a lot of parent companies are actually listed and located, it can happen in other countries as well. And I know from the Canadian perspective of the duties of companies just within the own company, the idea of shareholder wealth maximization is not as strict and robust as it is, let's say, in the United Kingdom. And so Canada is a less shareholder centric, not that it's not shareholder centric. It has a much broader view of what the benefits should be and who should benefit from the company. And so I think that is hopeful in a sense, that Canada could follow UK decisions. So Commonwealth countries will look at these cases. If we have a substantive decision in the Supreme Court in the United Kingdom, it will be persuasive in these countries. And so I think it's important that it's happening in the UK, not only because the UK is sort of the site of colonialism and where the project started and the site of a lot of these parent companies, but also because, UK law is very influential in Commonwealth countries. So I think it's possible, but having said that, I am an eternal optimist. I work in climate change, so you have to be. So, I can understand that people are just going to say, nope, it's never going to happen in Canada or outside of the UK. So, we'll see. But I think it's exciting to think about reframing companies, particularly in this inflection point around climate change, the impacts of climate change, reputational damage that they're suffering from climate litigation, even if those cases are not successful, the idea of racial justice and the Black Lives Matter movement. We're in this point, and sort of the shifts in generational perspectives of climate change. So young people have much different attitudes around climate change and the responsibility of corporations to climate change than my generation and generations before me. And so the idea that companies themselves are worried about being able to attract the best and the brightest as employees. They're worried about you. They're worried about you, basically. They're worried about the millennial generation not wanting to invest their money in fossil fuel companies as investors. They're worried about your consumer choice and habits. And so in this moment when they're worried, let's push them to change.
I agree. Thank you. We have another question. Do you think that with the growing importance of climate change and the role of large corporations, countries could start creating legal structures that are better designed to deal with these legal issues?
Yeah, so I want to say that I'm not, there are a number of corporate scholars that have been working on this issue for some time. And so Professor Janet Dean, who's, I worked with her in terms of my PhD in the UK, she drafted enterprise liability into a statute in Albania. And so they have this concept in Albania. She's been working with a couple of academics to really think about reform exercises in the United Kingdom. I think if these cases are successful in the Supreme Court, and the Supreme Court seems very focused on their perspective of this duty, which is much broader than the Court of Appeals duty, the perspective of it. So the Supreme Court is being very dogged and diligent about, nope, this is what we meant when we said this. So if those cases continue, then I think a legislative fix would actually be better for companies in the United Kingdom, because it would be much more predictable. The reason why companies didn't like piercing the corporate veil to begin with is because it was so unpredictable. They didn't know when it would happen. And so I think there's a possibility for reform, but again, you know, I live in hope. So
Thank you. We have one more question.
Sorry, I also want to say, in relation to climate change itself and climate litigation, the opposite side of that is, particularly in terms of legislation in the United States, there have been moves by carbon major companies to get indemnities from the litigation. And so, for example, there have been discussions about, you know, we'll accept, let's say, a carbon tax. I don't know that a carbon tax will be passed, but we would accept a carbon tax if we can get indemnities for, you know, against all of this litigation that's going on in the future. So, you know, there are, obviously, they are thinking about trade-offs as well.
Speaking of trade-offs, we had Stanley earlier who was asking about how, well, saying how it would be helpful to hear about a compare and contrast between climate migration versus climate-related international assistance for SIDSs, and what the trade-off between focusing climate-related international assistance is between focusing it on migration, displacement, resettlement, or developing resilience.
So yeah, it's a good question. So climate finance is a huge and difficult part of the climate negotiations. It's always one of the last things to be agreed, and it's usually never satisfactorily agreed. So there is structures within the Paris Agreement and from the United Nations Framework Convention on Climate Change around obligations, or I don't even want to say commitments, statements by global north countries that they will contribute to climate finance, which will help developing countries. We saw there's a green climate fund that's been established. What has not been so clearly, and that's usually for adaptation. What has not been so clearly linked is the relationship between loss and damage and climate finance. And part of that was because the provision for loss and damage in the Paris Agreement was not linked to the provision on climate finance. That was a mistake. But now it's very clear that climate finance applies to loss and damage. The Green Climate Fund has this discrete window for loss and damage, and to be able to, the problem for small island states is that just applying for the finance, the paperwork and the hurdles, the reporting requirements, it's a lot to handle. And so they want sort of fewer barriers to access this. And so the Green Climate Fund has been working with SIDS for a while to do this. But having said all of that, there's not enough climate finance dedicated to adaptation. It's a very contentious and sensitive issue. Developing countries are very angry about this because they're having to basically finance their own climate change adaptation, which is not fair. And that's particularly the case with small island states. In relation to climate-induced migration and displacement, there's not dedicated funding for that I know of. There is a task force that was set up under the Warsaw International Mechanism that is looking at climate-induced migration and displacement, but no funding is attached specifically to those issues, partly because it is extremely sensitive. And so global north countries do not want to be financially responsible to compensate for loss and damage generally, because that could be obviously very expensive. And in the Paris Agreement, in the decision that accompanies the Paris Agreement, there was a statement saying there's no liability for loss and damage. So small island states were very clear to push that statement outside of the Paris Agreement, which is a treaty, into the accompanying COP decision, which has sort of questionable or unclear legal implications. So all that to say, it's really sensitive. It's a really sensitive issue. The good news is that the Biden administration has confirmed that they will be contributing to international climate finance again. So obviously the previous administration withdrew from the Paris Agreement and withdrew obviously from climate finance commitments that the United States had made. So.
Mm-hmm. Yeah, the new administration is definitely hopeful. Talking about global North, global South relations, we have Bradley who says today, seem to focus on global North liability for global South loss and damage, but do you know of global South corporate law or other laws, for example, human rights law in Latin America, that can apply to global South companies?
Yeah, it's a great question. So I'll start with the global north example, then I'll move to the global south. So France has what's called a duty of vigilance, where they're looking at international human rights law and requiring companies to report on their human rights obligations and any sort of infractions of that. So that's been one of the few pieces of legislation that, obviously, other than the OECD and the guiding principles on human rights, like within domestic legislation that I'm aware of. My understanding is, having looked at the reports from companies in France under this duty, it's been largely sort of like corporate social responsibility reporting, very vague, not very specific. There's been some really exciting climate litigation in Latin America, and South America, where rights of nature are given specific rights within that country. And so that has been, and there's been a vibrant set of pieces of climate litigation in Canada as well. So I'm co-authoring a paper with Professor Sarah Seck from Dalhousie, specifically on climate litigation, and we're looking a little bit at companies. So South America has some interesting jurisprudence around it. Climate litigation in the global South is just emerging, and so it's been a really interesting set of cases. In Pakistan, one of the most impressive cases that I have seen is the Lagari case, where the court actually told the government to set up a climate change commission to actually implement adaptation requirements, very much linked to human rights and international human rights obligations. But the gap, I think, is how that relates to companies. And so if there is sort of this national legislation, I'm not aware of a global South country in the context of climate change that is specifically imposing obligations on companies. But for example, India, in the corporate social responsibility context of its company law, does have a really innovative provision that says companies have to pay a certain amount of money, basically like a tax, which is dedicated to corporate social responsibility. And so because of the Bhopal accident in India, India has had a really fairly liberal approach to corporations and corporate law, very much focused on corporations as not harming, basically, not causing a tremendous amount of harm to its population. So I think India is probably one of the more progressive examples, specifically in relation to corporate social responsibility and obligations on companies. Other global South countries, as I said, I think are just developing national frameworks around government responsibilities for climate change for their own citizens. That is obviously very sensitive, because a number of global South countries don't feel like that's their fault, right? I mean, they didn't cause this, so, they are having to manage it. But I still think that little piece with global South countries and companies is missing.
Mm-hmm. Yeah, it's interesting to see the reimagination of all these constitutions. I know in Ecuador and Colombia that have been institutionalizing nature's rights. And I think that's so hopeful, but at the same time, you do see the limits to it, because some of these countries are dependent on the continued development of or extraction of resources, sadly.
And there's also other much larger systems like the World Trade Organization and investor state dispute resolution systems. Like international financial law has really not been on the side of developing countries to be able to impose these obligations on companies. And there's there's not sort of strict binding international human rights law either, and companies are not states. So it's a challenge. I think it's a real challenge. And there are lots of capacity constraints within developing countries. Even if they had the law to implement it, it's really hard.
Mm-hmm. We have a question from Elijah, who says, first of all, thank you for the insightful presentation. Do you have any suggestions for community players to encourage community engagement when it comes to building resilient communities and adopting anti-oppressive and anti-racist frameworks when it comes to climate justice?
I think that a lot of organizations, particularly young people, and I was very interested to see that some of the actors in the climate justice protests of young people sort of translated that experience into the Black Lives Matter movement and the protests around Black Lives Matter. So I think there's always been this really interesting connection, which is much more explicit and should be now, between climate justice, climate injustice, and racial injustice. And so I think that that is really important. I think it's really hard for me. I'm not it's really hard for me to actually tell communities what they should do in terms of advice. I actually find that it's better for communities to do it themselves because they know a lot more than I do. And so I'm not an expert on community development and planning because I see some of these NGOs and young people and they kind of know what they need to do. I think the fusing of climate justice and racial justice and economic justice in this moment we are in is really important. And I think that a lot of these communities get it and they know. I think in global north countries, the environmental justice movement is now gaining a lot more ground, particularly in the United States, because of the change of administration. I think in global south countries, it's a different story. I had slides, but I had so many, I didn't show them. Great slides about communities in small and developing states that are very sort of gender focused and women focused. I think community organizing and suing governments in global south countries is very different and very difficult, mainly because we are seeing an increase in the murder and death of environmental activists, particularly in the global south. And I know from experience in global south countries that it is a dangerous business to do that. And so I really admire the people that do that work and that fight in global south countries. I think it's very difficult work to do. And so I will say that I think this moment to be able to do this, and that's particularly the case when you're going up against companies as well, right? Like there are, instances where companies themselves are implicated in some of these incidents. And so it is dangerous work. And so I kind of don't want to tell communities in global south like go do it, go fight, go do it. I think it's really hard to do that kind of work, and I think that communities themselves are being very proactive. I think as lawyers, what I would really say to lawyers is the things I tell my law students in environmental justice is listen to the communities themselves, like listen to what they want and try to translate that into whatever avenues you can get that into in terms of legal claims. And I think doing the work as a lawyer with some of this litigation that we see coming out, and also luckily the reinvigoration around environmental justice provides at least some policy space for NGOs to be able to do the work that they want to do. And so I think if you are a law student or you want to be a law student, I think it's a really good opportunity to use this as a career to put your passions basically through a law degree to be able to help these communities. But step one is listen to what the communities themselves want, and don't go in like a lawyer, which we always do, and say, this is what I'm going to tell you to do. That's not okay. Yeah.
Thank you. I really appreciate that
Yeah, you're welcome.
so much.
All right, so I think we'll have one last question that just popped up in the chat. I think it's a bit similar to the points that you just touched upon, but Stanley's asking, what kind of covert efforts can Global North activists provide for Global South activists?
Yeah, so I think not just covert, but overt assistance is happening. So I do a little bit of research on climate litigation in the Global South, and we haven't actually been able to empirically prove this. And part of it is I don't want to either. I'm quite happy if it stays covert. But there are relationships between NGOs in the Global North and NGOs in the Global South that are sharing experiences around climate litigation. So we have a pattern that's emerging in the United States. It's also happening in Canada as well with youth-led climate litigation. I think that's also a really interesting element for students to get involved, particularly if you're interested in law, to join those NGOs that are suing, because I think you get a lot of experience about how court systems work or don't work. But we do know that there are linkages between NGOs that are specifically bringing litigation and law firms in the Global North, and they're working with partners in the Global South to bring litigation. So it is happening, and I think that sharing legal expertise, and I don't want it to be just one way either. So some of the papers I've written on climate change in the Global South is really showing how much more innovative litigation in the Global South has been. And it could actually teach litigation in the Global North a few lessons, because I think it's been really, particularly this case in Pakistan, for example, some of the cases, Melanie, that you have mentioned in Ecuador, Colombia, have been really innovative, really pushing constitutionalism and the concept of environmental human rights and rights of nature in a way that probably couldn't happen in Global North countries. So I think it is a symbiotic relationship, but I think in terms of like funding and people and capacity, that's been really helpful from the Global North to the Global South. So I think, Stanley, if you want to email me, I can think of ideas of NGOs that are doing that collaborative relationship. But yeah, no, I'm happy. Elijah Stanley, if you want to email me, please do. You can find me on the Lewis and Clark Law School website. So yeah, my email's there. I think it's on the slides too.
I think that's a really hopeful place to end for today. I don't know if there were any last minute questions from the group.
I'm so sorry I'm not at McGill. It's so sad.
I know, I wish so too. It would be so fun to just kind of informally hang out after and get to chat. Wow, this was incredible. Thank you so much for your time and your insight, and I really look forward to following your work.
So, sorry, I should have said at the outset, I'm terrible at publicizing my own work. This is a paper that I'm submitting. This is based on a paper that I'm submitting to Current Legal Problems in the UK, which is about these UK cases. So if anyone is interested, I can share when it's published. I'll happily share the link with you. It'll end up going up on the website at Lewis and Clark.